The only other course of business right now is Mr. Solouri's garage and breezeway. And Mr. Burrows, are you going to be presenting or doing anything about it, or?
If I may, Mr. Chairman, if I could speak for a few moments on the application.
Sure. Board members all have a copy of what you mailed out.
Okay. Thank you, Mr. Chairman and members of the ZBA. My name is Jim Burrows. I'm an attorney in Watertown, Sly and Burrows, and my office represents Bob and Anna Solouri in this application. I did submit a copy of an application with exhibits dated February 22nd, 2013, and I would ask that that be included in the record for this particular matter. And what I'd like to do, if I may, just for a couple of minutes, is summarize the background, the underlying facts, as I understand them to be, what we're asking the ZBA to do this evening, and the basis for that request. Briefly, Bob and Anna Solouri purchased property here in the town on County Route 7 in June of 2010. It's in the town's riverfront district. The property was then improved with a single-family home at that time, and that is their family home. They looked to add a garage 28 by 30 feet with a breezeway attached to the house in early 2012. During late summer, early autumn of 2012, the Solouris contracted with local gentleman, Mr. Green, to construct that garage. But before they began that process, they recognized that they have to dot their I's and cross their T's. They were then able to confer with, at that time, the town's zoning officer, Mr. Ed Bender, to find out on what they needed to do in order to build this garage. Mr. Bender explained the process for a zoning permit, also explained the process for needing to get a building permit for the garage. And that property is a little bit unique because what travels across the property is County Route 7. And Mr. Bender cautioned to make sure that you check with the county's right-of-way agent to make sure that you don't build too close to County Route 7. They began that process. In late September 2012, they submitted an application for a zoning permit, and you'll find that that application, as approved, was Exhibit A to my submittal to the board. And what I'd like to also just drop off, it makes it a little bit easier also to visualize it, is a copy of the sketch plan that accompanied that application. And it shows the property, and it shows the house and the proposed garage. And that's definitely part of the record. And then to make it a little bit easier, you'll see with that submittal was attached to Exhibit, I believe it was G. Nope. Exhibit F was a copy of the survey map. And what I've done is because that's such a small copy of the survey map that's attached to your exhibits, I've got a larger copy that I'll submit to the board. And I've highlighted it somewhat. For our purposes here, what it simply shows is the boundary of the property, and then it shows the river. It shows the existing house highlighted in green, and it shows where County Route 7 travels across the property. And then you'll see the circle, the red X. That's just my mark on it. Again, it shows approximately where the garage was to be. But again, you'll see with Exhibit F, with the submittal, it's got a smaller portion of the survey map. But I think it's important just to get a grasp of what's going on here with it. So the Solouris applied for and were issued a zoning permit from the town zoning officer dated October 1, 2012. They then went to the county to check on a building permit and also to check on the county's right-of-way. They learned from the county's right-of-way agent that, yeah, Mr. Bender was correct. You've got to be careful when you try to build near a county right-of-way. You have to be at least 33 feet off the center line of that county right-of-way. The county looked at the application, the sketch plan, and saw that the garage, the nearest edge of the garage, was going to be more than 33 feet off the county right-of-way. So the county right-of-way agent approved it. The county also issued a building permit. I think it was dated November 8th, 2012, and that's, I believe, is Exhibit B with the enclosure to the ZBA. So armed with that, the Solouris contracted with their contractor, and they actually began the construction of the garage. They spent more than $40,000 on that garage. building it in conformance as far as they knew with the zoning permit and the building permit. At the same time, there was a change here in the town. The town has a new zoning enforcement officer, Mr. Millington, and what happened was Mr. Millington, in early December 2012, he inspected the property and he determined that he did not think that a zoning permit should have been issued, and he issued a stop work order dated December 7, 2012. The stop work order explained the reason why he issued the stop work order. He indicated it was an invalid zoning permit, improper setback. That's what it indicated, and that's Exhibit C that's attached to the February 22nd submittal. So with that, the Solouri's tried to find out, well, what does this mean? They'd already built the garage, they'd already spent more than $40,000 on the garage, they had the zoning permit, they had the building permit, they had the right-of-way agent from the county issuing an approval for this. They didn't know what was going on. The question apparently came up, the zoning law in the town of Cape Vincent, not unlike a lot of communities, you know, it's tough to get into some of that. Sometimes there's a lot of twists and turns and a lot of loose ends that from time to time your town boards need to tie up. And some apparent confusion had arisen in connection with what was the rear lot line, so far as we knew. The zoning ordinance here in the town of Cape Vincent, and I'm referring to Section 9, it identifies the front lot line. The front lot line for waterfront property is just that, it's the waterfront area. And that also defines the rear lot line. The rear lot line, you can have one rear lot line per lot, and the rear lot line is defined in Section 9 as being the lot line furthest, opposite from your front lot line. We understood that to mean that the waterfront is the front lot line, that the furthest lot line would be the rear lot line. It's more than 150 feet back, that was the rear lot line. Now, apparently there was some confusion because of the fact that whether the 25-foot setback, which applies here, is measured from some part of the road or whether it's measured from the rear lot line. Well, what I'd suggest is the rear lot line is covered in your zoning at Section 9. The setbacks are addressed in your zoning as well. Section 3.3 indicates that there's a 25-foot setback, and the 25-foot setback is measured from the rear lot line. And again, we think the rear lot line is just what it says and what it means, which is the line most distant from the waterfront line. We know we've got one parcel because the deed to the property is one parcel. It's very explicit, it's one parcel. The survey to the property is very clear, it's one parcel. The town says it's one parcel because we've got one tax parcel number that's been designated. And so the question is what effect, if any, does County Route 7 have on that property? And that's a fair question, and it's tough to grapple with it. All I can say is the county has decided what it means when it's got County Route 7 across there. The county's right-of-way agent has looked at it and says, no, it used to be a state route. The state had a right-of-way, nothing more than a right-of-way. The state, when it no longer used what's now County Route 7 as a road, the state gave it back to the county, and the county has a right-of-way. And you'll see the submittal that's attached as Exhibit G to the application materials. The county has looked at that and said, no, County Route 7 has a right-of-way. County doesn't own the property, and that's important because that right-of-way is a lot like a utility easement that National Grid might have. It doesn't create anything more than a right-of-way across the property. Well, that's not to say that it's not relevant with something like this. Well, the county says it's very relevant. You've got to be at least 33 feet off the center line of County Route 7. So as we looked at this, what we were here for was one of two things. One was to say, would you consider rescinding, vacating the stop work order simply because of this misunderstanding or this confusion? I think the basis is here to indicate that the rear lot line is what it says and what it means. It's that line that's far more distant. The property can only have one rear lot line, and we think we know where it is. It's the line I've marked with the red line, and that's more than 100 feet distant from the nearest edge of the garage. But I recognize that, you know, that there are always issues with a municipality zoning. So when we looked at this, you know, I recognize with Mr. Solouri and Mrs. Solouri that we're here because we need some help. You know, we've got the contract, we've got the garage built, spent more than $40,000 on it, and our hope is we'd like to get permission to keep it in its place. If we can't get there by rescinding the stop work order, the alternative request is would you consider granting an area variance? And that's specified in my February 22nd submittal. And I know that you folks, you're experts when it comes to area variances. That's what you do in relevant part under your zoning ordinance 5.3. That's one of the things that you've got that power. I know you've got the expertise and the training is to look at with the area variance. It's covered in your zoning ordinance, and it's also covered in the town law 267B. And when you get at that, it's really a balancing test to balance the benefit to Mr. and Mrs. Solouri if they can get the variance to keep this garage in place against the detriment to the neighborhood if the variance is granted and the garage stays in place. And then there are 5 tests that you'll look at under the town law, and I know that you folks are all familiar with it. You've got it in your zoning ordinance. So I won't belabor that point, but I think, you know, what really jumps out at me, you know, we do quite a bit of municipal work for municipalities and also for applicants like Mr. and Mrs. Solouri who deal with these issues from time to time. And what kind of jumps out at me is that the Solouris are here not because they're trying to get away with something, not because they overlooked something, and now after the fact we're looking for relief from the zoning ordinance. The Solouris are here because they thought they followed the zoning ordinance. They thought they followed what needed to be done. They thought they dotted their I's and crossed their T's up front. That's why they got the zoning permit and the building permit and the right-of-way agent. And now we're stuck. And we've got the garage, we've spent the money, and our hope is that as you look through this, in the expertise of your discretion, whether you would agree to let them keep the garage where it's located under, you know, one of 2 views. Either that under the circumstances, the stop work order could be vacated, it could be rescinded, or as an alternative that Mr. and Mrs. Solouri could get an area variance to keep the garage there. But that's pretty much where it is. I mean, we need some help. I admit that we need some help, and I recognize that you folks are the only ones that really can offer that help to the applicants. And that's what you're here for, is to take a look at these issues and try to do your level best. Again, I'm here with Mr. Solouri and his son Chris, and you know that we don't hold anything back. We'll answer any questions that you might have. If you've got anything at all that you'd like to ask us, you know, we'll do our best to get the information to you. And we thank you for your consideration.
Any other comments from the audience?
Could I see the permit, the building permit from the county? I didn't get to it, I guess.
That's a letter from the county.
From the county highway
Oh,
department?
John Wiley issued a building permit. That's right here.
The building permits exhibit B.
And that really has nothing to do with what we do.
The letter from the county right-of-way agent is exhibit B. And what happened was after the stop work order was issued, the Solouri's asked, you know, would you put this in writing that the county doesn't have a problem with the location. And that's what resulted in that December 12, 2012 letter.
Could I ask at what point did the breezeway enter into what you guys were thinking about?
I think at the earliest point, if I may approach, the sketch.
This is the only sketch that came with the permit.
That's the original sketch right there.
Yours is the first time I've seen it.
Is it this that I dropped off?
Yeah.
This is why it was a sketch of the property.
We never saw that in
Right.
our office.
Never.
Okay.
This is the sketch. The
Okay.
breezeway
It's not there.
is not on the permit.
It's
Here's
not
the
in
original application.
Okay.
There's the sketch.
Okay, this is a sketch that I had. I didn't know that I submitted. And what you'll see is with my submittal, I've got a copy of the zoning permit and the approval, but I didn't have anything further than that, so I just dropped that off. It does show where the breezeway is. It doesn't extend beyond the eaves of the structure.